All right, our final case this morning is Dean GAST and Randy Brewer versus JENNER, or I'm probably butchering.
Mr. Handel, how do you pronounce his last name? Gene Jenner. Okay.
Okay. Well, I was trying to do it properly, but and your name, please, sir?
My name is Dean GAST, Your Honor.
All right. Is Mr. Brewer going to argue this morning, or you?
He is not, Your Honor. I will be arguing for both of us.
Okay. Would you like to save some time for rebuttal?
I would reserve 5 minutes for rebuttal, Your Honor.
Okay. The clock will indicate that, but I'll try to give you a wave of the hand as well so that you can be aware of that.
I appreciate that.
All right, sir, you may proceed.
May it please the Court, my name is Dean GAST, and I am the appellant in this case. The cause below, alleged libel and defamation. Upon appellee's motion, the case of Mr. Brewer has been consolidated for appeal. Central to the issues on appeal in this case is that hyperbole was never pled. Appellant argues it is therefore waived as a defense and not before the court as grounds for summary judgment. I have submitted this court's holding in Deluxe Motel v. Patel as supplemental authority directly supporting the argument on this issue. JENNER moved for summary judgment below on 3 grounds. First, that GAST was a public figure, and as I speak, GAST interchangeably add GAST and Brewer. GAST was a public figure, that actual malice could not be proven, and that JENNER's statements were protected as pure opinion.
And the trial court ruled against them on that position, as I recall. Is that correct?
The trial court ruled that GAST was a private figure. I don't believe the trial court made any finding at all as to the presence or absence of actual malice. The trial court's opinion and final judgment was based primarily upon a finding of hyperbole, going back to the pleading issue. The record evidence shows that JENNER knew his statements were false, or that he published them with reckless disregard to their truth or falsity. At hearing, JENNER argued his statements were hyperbole. That was the sum essence of his arguments. The 3 grounds stated for summary judgment were never touched. Hyperbole was not pled in answer. It was not.
Does it have to be?
Pardon me?
Does it have to be?
Well, my understanding of 1.140 is that if you don't plead it as a defense, you lose it.
Well, if you don't plead affirmative defenses as a defense, you
yes, but it wasn't pled in answer.
How is this an affirmative defense?
Hyperbole is an affirmative defense that it would admit the cause, but deny the cause of action due to the fact that there was lack of conditions precedent. He would have to plead hyperbole either as an answer or an affirmative defense before he's willing or able to take advantage of the ground.
Why isn't that subsumed within the concept of opinion?
Because hyperbole is a valid defense only under the situation where language in the statement, which is figurative or abstract, negates provably false defamatory fact. On the other hand, pure opinion is simply a question of was sufficient factual background information published with the statement, or was the reader otherwise aware of that background. So even Mr. Jenner admits in argument that opinion is not hyperbole. That's in the record at 57 line 22. His statement goes on, if the statements fall within the parameters of what is called rhetorical hyperbole, which is not really opinion. So there's no question that he's admitting the fact that they're not the same thing. Yet in spite of that admission, he's asking the court to ignore the pleading failure, to subsume the hyperbole defense within his pled opinion defense, or to subsume it within his general denial. And I don't think he can do either, because first of all, Walker v. Walker says you can't have a judgment on grounds that aren't stated. You can't have a summary judgment on grounds that weren't pled for. That's exactly my argument here, is that there is a differentiation between pure opinion and hyperbole, that everybody is aware of it, and I believe there's because under 1.140B, that it would need to be pled specifically like any other defense. I don't think there's anything that just calling something hyperbole, you can't quite do that. I think Milkovich v. Lorraine Journal dealt with that, and I will talk more about Milkovich v. Lorraine Journal later on, but I think they very specifically call that fact into question.
Well, doesn't hyperbole mean an exaggeration?
Hyperbole, as I said before, it has to have exaggerated fact, has to have figurative language, has to have abstract language. It has to have something which would deny the believability of the statement. In this case, the statement had the words in it, the facts.
Okay. But if you've alleged that he made a false statement of fact, isn't it an exaggeration as opposed to just a denial of fact?
Isn't an exaggeration?
Yeah, I mean, if I say that person's as big as a house, now that's different than me saying that person is 350 pounds, right?
Yes, and that person is as big as a house would be hyperbole.
Right, and it wouldn't be a fact.
And it wouldn't be a fact.
Okay, well, you allege in your complaint that the person made a false statement of fact. So if they're denied as a fact, or a false statement of fact, then you don't need an affirmative defense. You can just say deny.
But he would have to, since that would be a denial of conditions precedent, he would have to plead that with specificity, would he not, Your Honor?
What are the conditions preceding?
Well, that the statement was false, that the statement was defamatory, and that there was damage because of it.
Maybe we're talking about two different things, but that doesn't sound like the condition preceding to me. That sounds like the definition of defamation.
That is the definition of defamation.
Why is that a condition preceding?
Well, I think what was argued below was that by calling what they initially called opinion hyperbole, that they could then skate out of the truth or falsity issue, which kills them under Milkovich, and they could label, simply by labeling something hyperbole, pass it off as a exaggerated statement. But there is no exaggeration in Jenner's language.
Well,
If you read the language, it's not there.
Which part of the language do you conceive as being, say, the worst? Would you agree that it's a nutcase, in that language you used?
Well, the paranoid nutcase, I mean, I cite a number of statements, but they really boil down to three general statements. Three statements. The one which implies the commission of a crime by saying that I/Brewer orchestrated the conspiracy to fire Isaac Turner, which would have been a crime either under 286 or under 836, depending upon the sense of the reader. The other statement is the rigged the city manager selection process, which also, as I was a serving member of a city board at the time, would have been a crime. And Jenner admits this in his answer brief, that this imputation is possible. So there's no question that the imputation of a criminal or unlawful act is there. And the third thing was the paranoid nutcase, which goes to the Eastern Airlines v. Gellert ruling, where if you write that down, if you question someone's mental fitness and you do it in writing, then you have a libelous per se comment.
And why is that not hyperbole?
Because there is no exaggerated language there. There is no...
Nutcase is not exaggerated?
Pardon me?
Nutcase is not exaggerated?
Well, I don't think I'm a nutcase.
I have no opinion one way or the other. I don't know you, so I
Yes.
guess. But I'm asking about whether or not the language itself is...
Well, the language itself would be interpreted by the individual hearing the language. As we found in this case, there was one judge who believed the language was defamatory, that it was libelous, and that it was mixed opinion. He gave permission to plead punitive damages. Later on in the case, there was another judge who obviously thought much differently. So we go back to what the common mind presumes. And where there's a question, as I brought up in argument at summary judgment hearing, where there's a question as to whether or not a statement is interpreted in a given way or in a defamatory way versus a non-defamatory way, it's a question for the jury. It's not a question for the court. You've said that yourself in Scott. You made it very clear that in a pleading issue where the question comes up, that it would be an issue of disputed interpretation or sense of the reader, and it would be an issue for the fact finder. And
Well, doesn't the trial judge, though, act as sort of a gatekeeper to those things? I mean,
Well, the trial judge, I guess, acts as a gatekeeper, but it acts as a gatekeeper only in the sense that there's no possible second, third, or fourth interpretation. If something is so clear as to be definable only in one way, then, as I understand it, it is the realm of the trial judge to make the decision that it's libelous per se or not.
Mr. Gast, I assume you're here because you're unhappy with the trial judge's ruling. Now, if you got that ruling and you told, your neighbor, or friend, or whoever, this judge is crazy, I can't believe he threw my case out, is that defamatory?
No, because I published the reason why I would believe he's crazy with the statement.
Well, what's the difference between crazy and nutcase?
I wouldn't go to a differentiation between crazy and nutcase. What I was going to is your comment, and your comment was, I would believe the judge to be crazy, and then I would have said, because he threw my case out. Now,
So how is that any different than if Mr. Jenner had written, and as Judge Rouse points out, I mean, his language was crude and more, I think, appropriate for a fourth grader than perhaps a member of the community. But in any event, how would it have been any different if he said, Mr. Gast and Mr. Brewer think that the city manager should be fired. That's an absurd position. They must be nuts if they think he's not doing a good job. I mean, I'm trying to understand how that's any different than you saying it, as people have said about, well, at least Judge Monaco many times, that was a crazy opinion that he wrote.
I think, Your Honor,
that was actionable. He'd be one of the richest guys in the world.
Well, if they make the statement and they do not take the protection available to them by publishing the facts upon which that statement is based, then they do open themselves up to whatever type of action Judge Monaco might care to institute. But in a statement like Jenner,
you think that if it's a defense, if you just simply said the judge ruled against me, he's nuts or he's crazy, that would be defamatory. But if you said the judge is crazy because he ruled against me, and here's the reason why I think he's wrong, as long as you give some basis to show why you think he's crazy, even though you might be wrong, you think that's not actionable.
well, Anson v. Paxson says that even if you do give a basis to think the judge is crazy, to use your example here, even if you do give that basis, and if your facts are incorrect or wrong, liability still accrues. So you don't get off the hook just by giving an explanation, but you must, as a part of your statement, publish the facts upon which your statement is based if you hope to have constitutional pure opinion protection.
Suppose the basis is obvious from the context in which the comments were made.
If the basis is obvious to the reader, that also qualifies as one of those things that it would then not be necessary to publish the statements. But it was not so in this case.
Tell me what the context was.
The context in this particular case was a group of statements that were written to an uninformed reader, making factual assertions without any supporting fact, and the reader was not aware of why those things would have been true or might not have been true. What the reader was led to believe through Jenner's statements, and you see in my brief that I've gone there repeatedly, the statements said, the facts, you need to know this. The facts are, I know, I can tell you, every single inference that the statement contains is an assertion that I know the facts and there are more defamatory facts that I haven't stated here. And that was pervasive through all three of the statements complained of. Jenner himself has maintained that his statements were true and accurate. He does that in interrogatory answers. That assertion alone creates a factual issue. Did GAST actually spearhead a conspiracy to fire Isaac Turner? Did GAST try to rig the city manager selection process in 2001?
Well, but in the context of politics, you know, I guess conspiracy is a word that could have a pejorative, negative viewpoint. Is it a conspiracy if I have an interest in local politics and I go to members of the city commission individually and say, you know, I really think that we ought to do X. You know, you really ought to refurbish the ballpark and get rid of the recreation director because he's doing a really lousy job. And I tell all 5 city commissioners or 7 city commissioners, and they decide that, you know, he's right. Let's can this guy and fix up the ballpark. Is that a conspiracy? Or is that simply just me exercising my right to speak to my public officials?
Well, that's basically you exercising your right to speak to your public officials, because what you didn't say in that particular thing was what you outlined in Hope v. Rissman so eloquently, in that when you have a conspiracy, it is a meeting of the mind to perform some illegal or unlawful act. It is not. There is no such thing, and this is in the record. There is no such thing as a conspiracy to do a legal act.
Mr. Gast, you're down to about almost just under 4 minutes.
Then I'll try to finish up here. As to the factual issues, I believe, apart from the pleading issue on the hyperbole alone, I believe that there are factual issues that preclude summary judgment in this case, and Jenner has not shown anything in his motion which negates these factual issues before the court. With the factual issue being there, did Gast do this or didn't, that alone precludes summary judgment. Next, Gast raises the issue that the statements are facially defamatory, libelous, and not hyperbole. I've said before that hyperbole is a viable defense only where abstract or figurative language falls in such a way that it negates provably false fact. In this case, that language is absent.
Let me just ask you to take a breath, because I know you aren't familiar with our timekeeping. When you see the clock says 3 minutes,
yes,
that means that that's your rebuttal time. So I want you to know that, I mean, you can keep talking and use your 3 minutes, but if you want an opportunity to rebut what Mr. Handel is going to say.
Then I will make just one final closing comment here.
Okay.
Notwithstanding the failure to plead hyperbole, Jenner argues that hyperbole is not subject to factual analysis. The Milkovich-Lorraine Journal decision directly refutes that. The Supreme Court chose to differentiate fact and not fact in Milkovich v. Lorraine Journal, and liability accrues in any statement sufficiently factual to be susceptible of being proved true or false. Jenner represented his statements as the fact. I think his statements are susceptible to such proof. I'll reserve the balance of my time, Your Honor.
Thank you so much, sir. Mr. Handel?
Thank you, Your Honors. May it please the Court. I think it's important here to be aware of the context in which we're dealing with.
Before we get to the context, let's see if we can reach some understanding of whether hyperbole is or is not an affirmative defense. As I understand affirmative defenses, an affirmative defense admits the act, says, I did this, but it isn't actionable or it isn't illegal. I did it, but I'm not liable. I have an excuse. So why isn't, if your defense as to things like the nutcase comment are that it's purely hyperbole, and that any objective reader would know that we're not rendering a psychiatric diagnosis, but we're rendering maybe a political commentary. Why isn't that an affirmative defense?
Well, I think for two reasons. One, what we have here is a clear denial of the allegations in the complaint. In other words, the complaint says...
You don't deny you said it. You deny it's libelous or slanderous.
That's correct. There's a denial that it's slanderous.
So, I mean, your defense is, yes, I said it, but no, it's not actionable, and it's not actionable because of X, Y, and Z. So you think it encompasses your hyperbole defense if you say, yes, I admit making these statements and sending these emails, but I deny that they're defamatory.
Yes, I believe that simply denying the central core of the complaint, the allegation.
So if the reason that you denied that they are defamatory was, well, for example, if the statement is true, your client writes an email that says, so and so is been convicted of a crime 10 times, is not worthy of belief, and let's assume that's true. They file a defamation suit against you. And is it sufficient for you to simply say, we admit the statement and we deny it's defamatory, or do you have to raise truth as an affirmative defense? Say, we said it and it's true. And since it's true, it's not defamatory.
I think in an instance where you're talking about simply a denial of the fact that it is defamatory. In other words, you're not denying that facts were said. I mean, that's for the purpose of a trial. For the purpose of whether the fact as alleged are actionable, it's sufficient to have a general denial. I mean, you're not, Mr.
So, for example, you don't think you'd have to plead truth as a defense or privilege or public figure or any of those things, potential defenses. Obviously, if I want to say certain things about Judge Monaco, which I do frequently, because he's a public figure, I have a certain amount of freedom that I might not be able to say about you. But you don't think that those are things that you have to say, for example, if he's going to sue me for defamation, I don't have to raise the fact that, because he's a public figure, he would have to demonstrate falsity and actual malice. Those aren't appropriate affirmative defenses?
Well, I would agree with the court that in the instance of privilege, it would have to be raised. There is case law requiring it to be raised. Certainly in the case of hyperbole, there is not. I mean, there is no case law.
What about the cases that say affirmative defenses have to be pled with the same specificity as a complaint? So if your defense is hyperbole, you're just saying that that's not really an affirmative defense, it's just a general denial? I mean, maybe we just have a different understanding of what an affirmative defense is.
Essentially, our position would be, as I said, twofold. One would be that the general denial would act to deny the fact, in this case, that it is actionable and it is hyperbole.
Okay, let me ask you to approach it a little bit differently then. Let's move away from the affirmative defense, because while I think that Mr. GAST my view of an affirmative defense may be a bit more in line with what Mr. GAST is advocating than what you're advocating, I'm not so sure that it's still not a no harm, no foul if the statement isn't still objectionable in the sense that, I mean, if we remanded the case and say you waived the affirmative defense, you'd go back and ask to amend your affirmative defenses, and in all likelihood you would get it, and we'd be right back where we are, which is if your client writes an email that says he conspired with others to fire the city commissioner and the guy's a nut job, is that hyperbolic and such that people would view that as a psychiatric diagnosis, or would they view that as political rhetoric? So I guess now let's go ahead and kind of get the meat on the bones and tell me why your client can write letters to people in Ormond Beach saying that he conspired to fire the city manager and he's a nutcase.
Well, the basis and the context from which these statements were made was a very tumultuous time in the city of Ormond Beach. Back in January of 2002, the city manager was fired. This created an uproar within the city. There were meetings, there were recriminations, there was a lot of back and forth going on within the community regarding these issues. Shortly thereafter, you have the emails that are in question here that were made directly connected to the political controversy. You have...
To whom were the emails? I noticed there were a number of them, and I noticed some of them were to newspaper reporters. Who were the rest of them directed to?
I think they were essentially letters to the editor or letters to the newspaper. This was essentially the gist of the communications. If one looks at the very nature of the communications themselves, it's clear that they're written in an atmosphere of exclamation. Mr. GAST points out that there isn't a detailed factual basis explaining why someone is a nutcase or someone is not, and so on and so forth. Well, that goes right to the heart of the issue. The remarks here were made as an opinion matter, as exclamations. This is what I believe. I believe that...
is it defamatory? I mean, laying aside the privilege I might have for speaking in the courtroom, I go down to you and I are at a bar association meeting where I don't have that same privilege, and I say, I've had a lot of cases with Diego Handel, and he's a real nice guy, but he's just a nutcase. Is that defamatory?
I don't think so.
Or you think that's just hyperbole?
I think
And I wouldn't say that. But, if I did, Judge Monaco made me say something like that. I mean, would that be defamatory?
Certainly
some
not.
lawyers might take that as, gosh, the judge is saying that this guy's a nutcase. I'm not going to send him any cases, refer him any cases. He's an immigration lawyer, does a good job. I'm not going to send him any more cases. If Judge Orfinger says at a bar association meeting he's a nut job.
I think the reason why the case law that has looked at these issues regarding nutcases and that type of thing has generally ruled that it is not defamatory is because it's simply an expression of opinion. If you start giving a detailed analysis as to why something is let's say someone is a nutcase, because he's got a psychiatric diagnosis, because of this, because you give a treatise with an explanation, that's a different story. But if you're merely expressing your opinion, particularly here, where we're talking about in the context of a firing of a...
So your viewpoint, though, is that really, if I say about someone, I won't pick on you anymore. If I say about Mr. X, not only a nutcase, but he's an ugly nutcase. The fact that I subjectively think he's ugly and nuts isn't actionable.
I don't believe
you think that's pure opinion or hyperbole, as opposed to me saying, well, I've looked at the DSM manual and I know that he's a paranoid schizophrenic because he demonstrates these symptoms, and I consulted with Mr. Handel's father, a noted psychiatrist, who confirmed, in fact, that he was a nutcase.
Yeah, I think, as the court points out, if you're talking about reasoned analysis and backing for the description you're given, that's a different story. But when you're talking about simply making an exclamatory remark...
well, doesn't your standard promote, it seems to kind of turn it on its head in the sense that if you just want to shout something out, if I want to just shout some defamatory statement out without detailing why I think that you're X, Y, or Z, that's okay. But if I actually sit down and give some reasons why I think you're a nutcase, that's not okay. If it turns out, well, maybe I was wrong, maybe you really aren't a nutcase.
I think that the distinction there is as to what's behind it and what the context is. If you're talking about a political discourse, issues of public opinion, issues which are relevant to the community, and you have people expressing vehement opinions, as the U.S. Supreme Court discussed in New York Times versus Sullivan, you're going to have vituperative remarks, you're going to have robust and wide open discussion. If that's the case, then simply in the course of that content saying his opinion as to this party or that party or the firing of this person is crazy, he's a nutcase, in that situation I would say that it's clear that
you think the context of this arising in the political arena gives it a different protection than something that might just arise at a Kiwanis Club meeting and Judge Monaco is sitting next to his fellow Kiwanian and says that, did you know that I just think that so-and-so is just a real nutcase.
Yeah, I think
that has nothing to do with politics, and he's just sort of gratuitously slamming the guy. You think that because of the First Amendment that we have to give this a greater protection? And
yeah, I believe that when it comes to public issues, the courts have laid out a path where it is encouraged to have open discussion. I mean, we're in a democracy where we don't try to restrain free speech, and we understand that when there are issues where there's great differences, great divisions, such as this one involving the firing of the city manager, there's going to be differences of opinion. And in those cases, it's clearly protected. Discussions regarding, someone being way out or being a nutcase, or there being a conspiracy to fire someone, those are all clearly protected, and the cases reflect that. So that when you're talking about, someone saying, like one of the emails, I'm sick of Ormond Beach being run by nutcase like GAST Brewer and Carter. I mean, those types of expressions are clearly in the discourse regarding this particular issue. So therefore,
you don't think that statement's really any different than if you took out the word nutcase and just said, I'm sick of Ormond Beach being run by people like Brewer, GAST, and Carter. In other words, just take it out. You think that those statements are roughly the equivalent of one another. I'm sick of Ormond Beach being run by nutcases like Brewer and GAST versus I'm sick of Ormond Beach being run by people like Brewer and GAST. Do you think that in the political arena, those statements are essentially equivalents?
Yes, in the political arena, making those statements is permissible, and the courts have said that we're not going to restrain people in their expressions. One of the decisions that's cited in our brief, the Kotlikoff decisions, talks about where there is discussion regarding a huge cover-up, conspiracy, and that type of thing. And the court clearly said, when you're talking about these types of cases where there's expressions regarding opinions on these types of issues, it's not something that we're going to prohibit or restrain. So therefore, it's clearly allowed. And if you look at all the emails in context, they were all done shortly after this event. There's discussions about things like you have exclamation marks, you have short sentences. You don't have, as I said, a long explanation of what it is, because that's what it is. It's Mr. Jenner expressing himself. You have Mr. Jenner as an activist in the community. You have Mr. GAST and Mr. Brewer, long political activists in the community, and he's basically saying, one of the emails, you must be very proud of yourself. I want to congratulate you personally. You managed to destroy the political careers and credibility of commissioners. These types of statements are, as I said, clearly not personal attacks on the plaintiffs, on the appellants here. They're simply expressions of opinion. And once again, since we are in the rubric of expressions to the public, there's letters to the editors, and those are some of the most protected communications that we have. We know that these are public issues. There are no specific accusations of criminal activity. It doesn't say you violated, this statute and that statute. You committed these crimes. Nothing of that sort. Simply saying that in this particular situation, there was clearly no specific accusations of any crime. It's also clear from the decision of Judge Rouse in the trial court that there was no intent to injure reputation. The court very clearly sets out that, and the court acting in its capacity as deciding between opinion and fact, which it is proper for the trial court to decide. The court clearly states that these do not expose the plaintiffs to distrust, ridicule, hatred, or contempt, and as a matter of law, they're not libelous. So there's no question that this has been properly addressed by the trial court. Regarding the issue of opinion, rhetorical hyperbole has been discussed as being part of opinion. One of the cases citing that is Palm Beach newspaper versus Early, and clearly when you have, such as we have in this case, the use of general loose language, which is used in an intemperate way, perhaps. If Mr. Jenner had more time and down the road he would have sat down carefully, he probably would have used a calmer language. But it's clearly that these statements are not false statements. These are the opinions that are expressed by Mr. Jenner in this particular case. To conclude, I believe that the court made the proper ruling below, that the First Amendment rights of Mr. Jenner were properly protected by the court. These expressions were made in the heat of a political battle. They were made clearly in an opinion format. There was no lengthy factual basis supporting these, which backs up the fact that they were clearly opinion. Therefore, we would ask the court to affirm the lower court.
All right, sir. Thank you so much.
Thank you.
You've got about 2.5 minutes remaining.
Let me ask you something. I know there's a difference between local politics and national politics. I'm trying to figure out what the difference is between your case and, say, two people arguing about the presidential election in front of a third person. And one of them says, you support presidential candidate so-and-so. He's un-American. He's anti-family. He's anti-defense. He and his buddies in Congress are conspiring to destroy this country. You've got to be crazy to support him. If you support him, then you're part of that conspiracy to destroy the country. It's local politics. I know is different because you're dealing with friends and other people in the community, but how is that different as far as a political debate and using language which is derogatory and maybe immature?
Well, I think at the core of the issue, Your Honor, is the fact that these statements clearly are false. They are provably false. There's direct testimony in the record that Mr. Jenner's assertions are not true. The pivotal determination, as was decided in Florida Medical Center v. New York Post, was for a statement to be defamatory as either opinion or hyperbole. The determination boils down to, is there a provably false element to the statement? In this case, in all of these statements, specifically in the ones that impute a crime, there is such a provably false element to the statement. In your example, it would be very difficult to impute to somebody about his political beliefs that just because you disagree with me that we shouldn't go there.
Conspiracy to destroy the country.
Well, conspiracy to
That's treason, right?
I guess, okay. Well, the court though has held that there's no general license when it comes to, in Miami Herald Publishing v. Ann, the court has held that there's, just because you're a private citizen, doesn't give you any, there's no right to defame you just because you're talking about politics. It's been very clear about that. That's the Florida Supreme Court decision 1984. And finally, this court, as in Scott v. Bush says, that where there's a question as to how the words were understood, it is a question for the finder of fact. I thank you, Your Honor.
Thank you both. That will conclude today's session of oral arguments. We'll be in recess.